went past the Abilene airport exit, turned around, came back, and redelivered those Venezuelan immigrants to that detention center. Not a word about that, let's call it curious midnight run. Were they just taking those detainees, out for a field trip, get some fresh air out beyond the four walls of the detention center in which they were being held? There's not a word about what in the hell that was all about. But, Trump's DOJ lawyers say, trust us, we wouldn't try to circumvent the Supreme Court's ruling. One more passage I want to cover. On page 13, they circle back to the notice issue. Although the government, the Trump administration, maintains that the notice provided was adequate, individualized factors, including a detainee's language ability or the family's pre-existing relationship with a lawyer, may well be relevant to a court's determination of the adequacy of a particular notice. So friends, remember how a few minutes ago I said, wait a minute, there is a tell in what John Sauer decided to include in this court filing when he said, in keeping with the context-sensitive nature of due process, the court did not mandate any specific notice procedure. And now, here we have it. They say, well, there may be some individualized factors that come into play as to whether the notice we gave was sufficient. Individualized factors like a detainee's language ability. You know what we're probably going to see in future litigation, friends? This is just my suspicion based on John Sauer trying to get in front of an issue that's coming. I mean, that is dropped in the middle of this pleading on page 13 for no apparent reason. Could it be that Donald Trump's ICE officials are just giving these detainees notice in English, and many of them perhaps don't speak or read English, and then they're going to say, well, they didn't invoke this right when we gave them that notice, so we put them on a bus in the middle of the night and headed them out to the Abilene airport before we realized we better turn around, because if we do that, we might be caught red-handed, right? That is sort of one logical conclusion, reasonable inference based on the way this was unfolding in the wee hours of Friday night into Saturday morning. What notice and opportunity to be heard mean in the context of the constitutional due process guarantee is actual notice, advanced notice, intelligible notice that a person understands and can have a lawyer assist under, the Sixth Amendment right to counsel and all. But the good news is, it sure seems like the federal courts, the trial court judges, the appeals court judges, up to and including the Supreme Court, are about done, are about fed up with these stupid games that the Trump administration has been playing with the constitutional rights of human beings. And they should be fed up, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.